If you think you fully own your property, you might be surprised to learn that someone else could have the legal right to use part of it. And here's what's even more shocking. You might have given them that right without even realizing it. I'm Tiffany Weber, real estate attorney in North Carolina at Thomas & Weber. I've done thousands of closings in the Lake Norman area, and easements are one of the most misunderstood aspects of property ownership I see. Today, I'm going to break down exactly how easements are created in North Carolina, and more importantly, how they can be terminated. By the end of this video, you'll know exactly what to look for in your deed and what rights you actually have. If you own property anywhere in the United States, this information is crucial. And if you're in North Carolina specifically, there are some unique aspects you need to know. Let's dive in. I'm going to give you some quick terminology. First up is dominant and servient tenements. The dominant tenement is the land that is benefiting from the easement. The servient tenement is the land that is burdened by the easement. Another way to talk about this is calling them the benefited and the burdened parcels. This will be important for later when we talk about how to get rid of an easement. So let me break this down for you. In my last video, I explained that an easement is a non-possessory right to use someone else's property for a specific purpose. But here's what most people don't understand. There are actually at least 4 different ways an easement can be created. First, there's an express easement. This is the most straightforward one. It's created by a written agreement, usually in a deed or a separate written document. When I'm doing closings, this is what we see most often. The document gets recorded in the Register of Deeds and boom, you've got an easement. Here's what's really happening. Let's say your neighbor needs to cross your property to get to the main road. You sign an easement agreement, it gets recorded, and now they or their successors in interest have that legal right forever, or at least until it's terminated, which we'll get to. Second, we have implied easements. Now this is where it gets interesting. These are created by the circumstances, not by a written document. In North Carolina, courts may find an implied easement when there's been an apparent and continuous use of the property that's reasonably necessary. For example, I see this a lot with family land. Let's say dad owns 10 acres, he builds a driveway across it and then splits the land between his 2 kids. Even if the deed doesn't mention the driveway, the kid whose land the driveway crosses probably can't just block it. The court might find an implied easement because it was obviously necessary when the land was divided. Third, there's easement by necessity. This is similar to implied, but it's specifically about property that was once owned commonly, and at the time of the transfer, the easement of whatever kind was necessary to the beneficial use of the land. A good example of this is property that would be landlocked if split and transferred, such that an easement over one property is necessary to be able to use the other property. Fourth, we have prescriptive easements. This is the one that really trips people up. In North Carolina, if someone uses your property openly, continuously, and without your permission, plus a couple other things, for 20 years, they can actually gain an easement right. To become official, this prescriptive easement must be litigated, and that's a claim called quiet title. Let me be really clear about this because I see this confusion all the time. The use has to be hostile. And that doesn't mean you're like fist fighting. It means without permission. If you give your neighbor permission to use your driveway, the clock never starts running for a prescriptive easement. Now here's where it gets really interesting, and this is what a lot of property owners want to know. How do you get rid of an easement? There are actually several ways, and some are easier than others. First is release by the easement holder. This is the simplest way. The parties who have the easement right, usually all of the owners of the benefited parcel, sign a document terminating their rights. It gets recorded in the Register of Deeds and the easement is gone. But here's the thing, you can't force someone to release their easement. They have to agree to it. And the owners of a burdened parcel can't unilaterally terminate an easement. Only the owners of a benefited parcel can do that. Second is expiration. Some easements are created with a specific time limit or condition. I've seen easements that say, for as long as the property is used for agricultural purposes, or for a period of 10 years. When that time is up or the condition changes, the easement automatically terminates. Third, abandonment. Now this is tricky in North Carolina. Non-use is not enough alone to qualify for abandonment. The easement holder has to show a clear intent to abandon the easement. I've seen cases where an easement wasn't used for 20 years, but because there was no clear intent to abandon it, it was still valid. Here's what you need to understand. North Carolina courts require clear and convincing evidence of intent to abandon. Simply not using the easement isn't enough. There needs to be some affirmative act showing they're giving it up. Fourth is merger. This happens when the same person ends up owning both properties, meaning the one burdened by the easement and the one benefiting from it. When that happens, the easement merges into full ownership and disappears. I see this sometimes when people buy neighboring properties. There's a case, the caption I can't exactly remember, but it states, it is axiomatic in property law that one cannot have an easement over his own property. That's because you don't need one. You own the property. Fifth is necessity. And just like you can gain an easement by necessity, you can lose one too. So So if the reason for needing the easement no longer exists, the easement may potentially be extinguished. But you've got to be careful here. Blocking an easement can lead to lawsuits. 6, there is eminent domain or foreclosure. If the government takes your property through eminent domain, some easements may be extinguished. Same thing with certain foreclosure situations, though this gets pretty complicated and depends on when the easement was created versus when the mortgage was recorded. So what does this mean for you? Here's what I tell all my clients. First, always get a title search when you're buying property. This will reveal any recorded easements. But remember, it won't show you prescriptive easements or implied easements that haven't been litigated yet, or any easements that maybe were just verbal or talked about between parties. Second, if you're giving someone permission to use your property, get a lawyer, put it in writing, and make it clear whether you are giving revocable permission or an easement. I can't stress this enough. Informal arrangements can turn into legal nightmares. Third, if you have an easement you don't want anymore, don't just assume it'll go away. Take action. Whether that's negotiating a release or determining if the easement has been abandoned, you need to be proactive. You may not be successful, but you certainly won't get anywhere just sitting and hoping. Let's recap what we covered. Easements can be created at least 4 ways: express, implied, necessity, and prescription. They can be terminated through release, expiration, abandonment, merger, necessity, eminent domain, or foreclosure. In North Carolina, prescriptive easements require 20 years of hostile use among other elements, and always put easements in writing to avoid creating a legal mess for yourself later. The bottom line is this: easements are powerful property rights. They can significantly affect your property value and use. But wait, there's one critical thing about easements I haven't told you yet. What happens when your neighbor's easement is damaging your property value by thousands of dollars, or when you discover an easement on your property that nobody told you about? I covered exactly this in my last video about easements, including the one type of easement that can completely destroy your property rights without you even knowing it exists. It's this video right here.